right, welcome everybody. Good evening. My name is Saman Golestan. I am a member of the Board of Directors of the Iranian American Society of Arizona and also a member of the board of the Iranian American Bar Association Phoenix chapter. Welcome to our webinar series, our civic engagement series. Tonight's topic is going to be new year, new laws. We're going to be covering all sorts of different areas of law, new laws in immigration and the state law, in the areas of employment, both from the employee and employer's perspective. You'll get some probate and estate tips. So it's going to be a really, really great session with the IABA Phoenix chapter. Many of the attorneys, all of the attorneys you'll hear from tonight, and all of these areas are on the board. Our program, of course, these webinars and online programs are made possible by all of our supporters and sponsors, members and our volunteers. So thank you all very much for supporting us, for sponsoring us, for helping, for volunteering. All of that matters and all of that really helps. The Arizona Persian Cultural Center itself was founded in 2008 in Scottsdale, Arizona. AZPCC is a registered nonprofit, a 501c3. A non-political and non-religious organization. In addition to complimentary webinars such as this program this evening, we offer several online programs and classes such as Persian calligraphy, book club, yoga, Masnavi, and Kanun. We also offer several Persian as a second language education classes. For a complete list of our events, please refer to our website at iasaz.org. Additionally, since the start of the COVID-19 pandemic, the Persian Cultural Center, AZPCC, has established two funds in support of those who have been hardest hit by COVID-19. To date, we have raised over $32,000 and have distributed over $24,000 in financial and in-kind assistance to those in need in Arizona. We appreciate any donations that you can make to help make these programs and our COVID funds possible. Again, please visit www.iasaz.org/support/donate to make your tax-deductible donation. And without further ado, we'll get into the main headline of the evening. Again, my name is Saman Golestan. Nice to meet everyone. Thank you for attending tonight. Our first subject is going to be about some state law changes from 2020 that have taken effect now. Some of those passed by the voters, others of those enacted by the legislature, and then some newly controversial proposals that I want to cover before I pass it on to one of my colleagues. So I'm going to, let's see, here we go. So let's start with some major changes in the state law. First, that come from the voters. As you know, in Arizona, we have the right of initiative, so the voters are able to make the law independent of the legislature. Probably the biggest change that came from 2020 that has just started to take effect this year in 2021 is the state legalization of marijuana by Prop 207. That means that adults 21 and over can buy and possess up to 1 ounce of marijuana, again in Arizona, and we're only talking about state law. Some of my other colleagues will address some of the other caveats shortly that you should know. But you are able to own up to 6 plants in your home, a maximum of 12 plants in a household with 2 or more people. Of course, the purchasers can only be from licensed and approved dispensaries. And as of a few weeks ago, I believe the list of approved dispensaries was across the state was somewhere in the 60 to 70 range. I mean, the Department of Health Services expedited the granting of the licenses. There are important to know there are no changes to the workplace laws. Employers can still enforce drug-free workplaces. There are no changes to the DUI laws. Major penalties remain for DUIs and DUIs that involve drugs, such as marijuana. There are strict penalties for underage use and possession of marijuana. And the law, even though it legalizes possession, again, for small amounts for eligible people 21 and older, it does not permit marijuana to be used in public places. The the other major change that we've seen in terms of things that have been passed by the voters, propositions that have been passed by the voters. The minimum wage as of the beginning of this year in Arizona has raised to $12.15. Last year it was $12. The 15 cents was a cost of living sort of inflation adjusted increase, and that was initially passed by the voters in 2016. Some major laws from the Arizona legislature. One I thought everyone should know is a texting and driving ban has taken effect as of January 1st of 2021. So that means while you're driving, you can't read or write texts. You can't answer the phone with your hands. There are limited instances in which use of the phone is okay. For example, at a stoplight or railroad crossing, you of course can use your phone to call 911 in the event of an emergency. But the fines are pretty significant, $75 to $149 for your first offense, $150 to $250 for repeat offenders. So, and that's in addition to, any other laws that are on the books that, could be, you could be cited for if you're using your cell phone, distracted driving or reckless driving or other things. So this is one more tool that for enforcement. So be careful driving out there. Make sure you have a hands-free device. So I want to cover some major bills that have been introduced this session of the legislature in Arizona. Our legislature is a half year, sometimes less, runs typically from January to May or June. So the legislature currently is in session. At the beginning of session, often many bills are introduced. There are hundreds of bills. I picked a few involving the areas that I have specialized in, primarily in elections and voting rights, in particular given the many changes we saw in the 2020 election in terms of voting reforms. The Arizona legislature has decided, or at least some members of the Arizona legislature have decided they want to tighten some of that up, and some of these are controversial. So that's another reason I wanted to bring them to your attention. Some of those changes include a bill called Senate Bill 1069. Now, this bill has already passed the Senate. The Arizona Senate. It has not passed the Arizona House yet, but it is pending before the Arizona House. It creates a mechanism by which Arizona voters would be removed from the permanent early voting list. That is the vote by mail mechanism in Arizona. When if you sign up, as it is intended to be permanent, as the name says, permanent early voting. You would always be the intent of the original initiative was obviously to have a permanent early voting list that was passed by the voters. The legislature has, some folks in the legislature have decided that they don't really like that for one reason or the other. And this bill says that if you don't vote by mail in 2 election cycles, both in the primary and the general, then they can kick you off the permanent early voting vote by mail list. A couple other controversial bills that are timely in terms of elections and voting rights. SB 1003, this has been introduced. It has not passed either house of the Arizona legislature yet, but this deals with the issue of mail-in ballots that might be missing a signature. So in this case, the proposed bill says that if you mail your ballot back and it is missing a signature, you would only have up until 7 p.m. on election day to correct that error. So there would be no opportunity to correct that error after election day, even if that ballot arrives on time before election day. It's notable because under current law, the current Arizona law allows up to 5 days correction period after the election, assuming your ballot arrives on time, of course. If the signature, if during the review, the county recorder deems your signature to be illegible or a mismatch potentially. So under current circumstances, you would have 5 days. This would be a difference. This would change that for missing signatures. And finally, probably the most controversial that I've seen, a lot of people are following this bill, and You may have heard about it. It's been in the news a lot lately. That's HB 2720. It has been introduced. It has not passed either house, either the House or the Senate of the Arizona legislature. But this would expressly give the Arizona legislature the authority to override the Secretary of State's certification of the presidential election after the presidential election, but before the inauguration. The current Arizona law requires the presidential electors to be determined on the basis of the popular vote in Arizona. And what this would functionally do is allow the legislature to override that decision. In my years of practicing election law, I have not seen such a bill introduced. So I was pretty surprised to see this. A lot of folks are surprised to see that. Again, it's only been introduced, but something to keep an eye on. And one other major bill that has been introduced, given some of the controversies over the governor's use of emergency powers in responding to this COVID-19 pandemic over the last year, and of course, criticism on all sides. Some people say too far, some people say not far enough. But in this case, a resolution has been introduced that would end the governor's emergency declaration, that would declare the emergency of the pandemic to be over, essentially, and end all of the changes that the governor has made using his emergency powers. So that's another thing to watch. I would expect there to be a dispute between the legislature and the executive branch, in this case, the governor, if that were to happen, and that might play out in the courts. We'll have to see. It would be interesting, of course, if, depending on the result of that, what tools a future governor would have to address a pandemic like the one we are currently living through. So some things to look out for. And that is all of the major some of the major bills that have been proposed, some of the major changes under Arizona law. And with that, I'm going to pass it on to Arash Tavanei to discuss some of the major changes in federal immigration law and some proposals in that area. Arash.
Thank you so much, John. Hello, my name is Arash Tavanei. I'm an associate attorney at SEMA Law Group. My primary area of practice is immigration law. And I'm also a member of IABA Phoenix. Today, I want to give you some information on new developments in the immigration area. Let me first start by saying that follow up on Saman's comments on legalization of marijuana. Marijuana has been legalized in Arizona and many other states. However, under federal law, it's still a controlled substance and it is illegal. So for immigration purposes, for non-citizens, if immigration discovers that you've been in possession of marijuana or grown marijuana or even worked at a legal dispensary, that is a deportable offense. So be aware of that. This administration, immigration is on top of this administration's priorities, and there's a lot of talks about a comprehensive reform. Not much has happened yet. You have to remember that the president cannot make immigration law. That has to go through Congress. President, however, has control over implementation and enforcement of immigration law. Some new developments, I think something the Iranian community has been waiting for is the travel ban, or also known as the Muslim ban. That has been rescinded. President Biden rescinded that ban on January 20th, his first day in office. 2 days later, on January 22nd, the Department of State issued guidance on how they're going to proceed now. Those cases who have not gone to the consulate level yet, the Muslim ban is not going to apply to them. Cases that are pending in the administrative process and waiting for approval of those waivers, they're going to be reconsidered without a fee or any action on your part. Cases that have gone through the administrative process and denied, now they are able to go back on the SEAC, on the MVC's website and upload their DS-260s again. but they do have to pay all the filing fees from beginning, and those cases will be considered. Biden has directed the Department of State to prioritize these cases and adjudicate them. However, most U.S. consulates abroad are still either closed or operating on limited basis, and those are due to COVID. So that's the good news. However, there are still obstacles. During the Trump administration, he did have another ban. It was an executive order to protect the US labor market against immigrants and some non-immigrants. That ban is still in place. Biden administration is reviewing it, but it is set to expire on March 31st. There is a pretty good chance he's not going to renew it. That ban does apply to anyone who's applying for a green card after April 23rd of 2020 and is outside the United States. Spouses and children of US citizens are exempt. Also, immediate family members of the armed forces and EB-5 investor visas are exempt. The rest, for example, parents of US citizens and their siblings, they are still subject to this ban. There's also a similar ban on non-immigrant visa. It mainly concerns H-1B and H-2Bs and J visas, but that is also set to expire on March 31st. There is also some travel restrictions right now. If anyone has been physically present in one of many countries that's on the list, is mainly China, Iran, and Schengen countries and the Great Britain, within last 14 days, they cannot enter the United States. Now, this does not apply to green card holders and citizens and their immediate relatives, but it does apply to every other kind of visa. Other changes, the Trump administration issued this administrative order called BAHA, or Buy America, Hire America, that restricted work visas severely, particularly H-1Bs. Biden rescinded that order, so everything goes back to normal, much easier to get H-1B visas. Starting January 26th, anyone traveling to United States is required to obtain a negative COVID-19 test within 1 to 3 days before arriving. That's something else to watch out for. Another thing, DACA, I don't think many Iranians qualify for DACA, but that is a deferred action available to those who entered the United States under the age of 16 and have been continuously present in the United States since 2007 and were under the age of 31 in 2015 and 2012, I'm sorry, and had no legal status in the United States. They could qualify for DACA. The Trump administration rescinded the Obama era DACA for a long time, and the case got litigated, but Biden is enforcing it in full and taking new applications. Also, there is a bipartisan bill introduced in the Senate to give a path to finally getting citizenship to DACA recipients, but that has to go through the Congress and everything, so we don't know that yet. Other changes, this is last days of the Trump administration, they revised the rules on naturalization. Before, pretty much, if you qualify for naturalization, they only reviewed the qualifications for naturalization and everything in the past 5 years before you applied. Under this new rule, adjudicators have to go back from the day you got your green card and make sure you never abandoned your green card, you never violated the terms of your green card before you can naturalize. This does create some problems. If you're anyone like my parents, they hold a green card, but they're never in the United States. You come once a year and go back. And finally, when they decided to live permanently in the United States, they would wait 5 years and become naturalized. Under this new rule, USCIS can go back and say, well, first few years that you had the green card, you abandoned your residency by not continuously residing in the United States. And they could deny your naturalization. They could also issue you a notice to appear to go to court for removal proceedings. But that was the last days of Trump administration. Biden hasn't rescinded the policy yet, but we don't know if it's going to be enforced or not. That's something to kind of watch out for. There's also a lot of talks about Biden proposing to increase the cap on immigrant visas. Each visa has a certain number that can be issued each year, and that's why if you apply for your siblings, it could take 7 to 10 years for them to get a green card. That hasn't been implemented yet. That is something that needs to go through the Congress, and the administration cannot act alone. So we'll see what happens with that. Other things that are on there's a lot of other developments, but they are country specific, and they're mainly concern asylum process for the southern border. I don't think it's going to apply to our audience that much, but if you have any questions you think it might apply to you, you should consult an attorney. That being said, I'm going to hand the torch, to our next presenter, Ms. Afsanieh Rassti, who's going to talk about estate planning.
Thank you, Arash John. I'm Afsanieh Rassti, and I am an associate at Lincoln & Wink, and I specialize in the area of estate planning and probate, also including appointment of guardianships, conservatorships, adoptions, financial exploitation of vulnerable adults, and some contested trust and estate matters. But today we're going to primarily just focus on estate planning. Give me just 1 second. Oops. Just skip through these. All right, so estate planning essentials. So I always like to joke around and say, hopefully you never have to consult an attorney, but if you do, I hope you have to consult an estate planning attorney, because an estate is something that you have and that you need. So first, basic common misconceptions and myths about estate planning. No, it is not just for the wealthy. We all have an estate to some extent. Another misconception, I'm too young to worry about an estate plan. So it doesn't matter how old you are, how young you are, whether you're married, not married, or how much wealth you have, you all have an estate that you want to plan for and build as things change. Another misconception is that I'm married and everything will go to my spouse anyways, which is not true. And this is where a lot of litigation disputes arise. My family will do the right thing. Again, money brings out the great in people, and I have heard all the stories under the sun. So making it clear within your estate plan what you would want to see happen and how you would want your assets to be distributed is something that we all want to plan for. So essentially, estate planning is planning for the unforeseeable. Next here is ignoring that life happens. So living through a pandemic, none of us foresaw a year ago that we would be living in a pandemic a year later. So again, it's not the most attractive subject to talk about, but at the end of the day, we're all going to pass one way or another. So we want to plan for it and ensure that our families are protected by creating an estate plan. Next misconception, and I've heard this more often than not, that if I pass without a will, the state will get my assets, or if I have a will, I don't need to worry about probate. So probate is the big trigger word here. You've all heard about it, and maybe perhaps you've had a family member pass and had to go through the probate process. Keep in mind that probate is different from state to state. Arizona's kind of stuck in between, whereas states like California and New York have a very stringent probate process. But bottom line, doesn't matter where the probate happens, it's very costly, it's very time consuming, most likely need an attorney to go through the process. And if it's something that's avoidable, why not avoid it? So we'll touch on probate in just a moment. But last thing here, once I create an estate plan, I'm golden. So I meet with a lot of clients that have set up an estate plan, you know, maybe 5 years ago, a lot of clients, maybe 30 years ago. They forget about it, put it on the shelf and think they're all set. However, as we all know, things change day to day. You know, we might create an estate plan when we're single and then get married, have children, have a divorce, you know, the natural events that life happen. We want to account for every single thing here. So once you create an estate plan, you always want to be mindful to update it every 3 to 5 years, and make sure you still like the way everything is working. I always like to tell my clients, so when before I went to law school and decided I wanted to be an estate planner, my parents set up an estate way before that. And then I started practicing in the area and realizing the importance of an estate plan and updating the documents and reviewing them from time to time. And at that point, my parents' estate plan was 15 years old. And me and my brother were still minors. And so seeing how things can change is very, very important. So always keep in mind, great if you have an estate plan in place already, please always reflect on it and let your family members know that you have one. So next here, estate planning must have. So what you see here, the legal documents you see here are all essential and all serve a very specific purpose. So first things first, a revocable living trust. So this is kind of a basic trust. So that's where you want to start. That's the starting point. There are, of course, very many different trusts that serve many different purposes. But as a basic starting point, a revocable living trust, the main purpose is to avoid probate, and 2, for asset protection, to protect our assets, ensure they are going to our beneficiaries. So revocable living trust, so it's revocable, meaning that you can amend the trust as needed, and the trust only goes into effect at the point, so when you pass. And at that point, your trust becomes an irrevocable trust. It's set in stone. No changes can be made to the document. Next thing here is a last will and testament, which is what you most of you have commonly heard of. So a last will and testament serves the purpose to appoint an executor of your estate. So in Arizona, we call them your personal representative, but they are interchangeable. An executor will kind of take care of the estate administration, take care of any funeral burial arrangements. And then additionally, for families that are starting out, a will also appoints guardians for your minor children. So the first 2 things here, your revocable living trust and last will and testament, only go into effect upon your passing. And for specific purposes, your revocable living trust could go into effect before then if you are incapacitated and the person that you've nominated to manage your trust, so a trustee, would then at that point step in and manage the trust earlier. But those are only in very specific situations. Next here, your powers of attorneys, your POAs, however, are living, breathing documents. And these serve a very fundamental purpose. So in the event you are incapacitated, unable to manage your financial affairs or make medical decisions, these documents come into play. So they serve the purpose of appointing an agent to make both your financial decisions as well as your healthcare decisions. So without these documents, without your powers of attorneys, you would have to go through a guardianship or a conservatorship through the court. So a guardianship would manage your well-being and medical decisions, and a conservatorship would manage your financial affairs. So essentially, they would be stepping into your shoes and making decisions regarding your financial and medical needs. So if any of you have ever gone through the guardianship conservator process, it is for the lifespan of the incapacitated person at that point. So unless for specific purposes where it is no longer needed, it is something that a court will supervise for the duration of the incapacitated person. So again, this could amount to filing annual guardianship and conservatorships with the court, and it can get very messy, and it's a very procedural process. So having your powers of attorneys in effect, so while you're of sound mind and able to execute those documents, would avoid conservatorships and guardianships appointments. And then last thing here, the healthcare power of attorney, there is also a general mental healthcare power of attorney. So if you have some sort of mental incapacity, that is another supplemental document, as well as a living will, where you would specify your wishes regarding life-sustaining treatment. So if you are in a vegetative state or irreversible coma. So again, these are the basics, and this is what I recommend as fundamental documents that would be a part of every estate plan. So here, basically what we already covered. So a last will and testament is a legal document in which an individual records his wishes as to how his possessions and affairs should be handled after his death. So this is where a lot of people get tied up between a benefits of a trust versus a will, and do I need one, both, or which one serves a, gives me the most protection. So a trust, again, like we talked about, avoids probate, as well as gives asset protection. It also gives us the flexibility and control to manage our assets. So keep in mind, with a trust, there are 3 different parties to a trust. So the person who creates the trust at one point in time will serve as the trustee, the trustor, and a beneficiary. So the trustor is the creator of the trust, the one who has the ultimate control of how the trust be set up, who should be the trustee, and how their trust estate should be distributed. So the trustee is the manager, and then the beneficiaries are the ones who inherit from the estate. So upon the trustor, the creator's passing, the trustee, so the person who will step into the shoes of the trustor and manage the trust, will come into play and distribute to the beneficiaries according to the terms of the trustor creator. So a lot of time, the flexibility with the trust can give an individual the ability to determine when and how much they would like a beneficiary to inherit, and set any sort of age restriction. So this comes into handy for families that have minor children or who don't want their children to inherit at 18. They can kind of manage that through the appointed trustee of how much their kids should receive and for when and what purpose. The trust can also provide privacy for trustors and beneficiaries as well. And then a last will and testament does not avoid probate, but passes through probate. So a last will and testament basically designates who would inherit under your estate. But depending on the value of the asset, so in Arizona, if it's a real property asset, so if you own property that is $100,000, which again, most property, real property, unless it's a vacant land, is going to hit that threshold point, would pass through probate. And then personal property, so anything that has a monetary value, so bank accounts, life insurance, retirement accounts, the threshold point that would trigger probate is $75,000. So if you don't hit those thresholds, so 75 for personal property or 100 for real property, there are simpler ways, what we call non-probate transfers, small affidavit transfers, to collect those assets. But otherwise, you would be forced to go through the probate process to have title passed from the decedent, so a deceased individual, to their beneficiaries, so their heirs. So here you see testate versus intestate. So a testate, if you pass testate, you pass with a will. And if you pass intestate, you pass without a will. So if you pass without a will in Arizona, your assets will flow through the Arizona laws of intestacy. And you see the link here, which kind of breaks it down. If you pass, who would be your next of kin and who would legally inherit those assets. So there are different formulas for different situations. So whether you have a spouse, don't have a spouse, have children, do not have children. But basically, if you have a spouse and have children, it would first go to your spouse, then your children if there is no spouse. If there is no living descendants or a spouse, then it will just go to your next of kin. So it naturally would just fall from parents to siblings and then so on and so forth. But that gets a little bit complicating, and that could be a whole discussion for another day. And then, so what is probate? So you kind of see a probate step-by-step listed below. So when a person passes intestate without a will, or if a person passes with a will and they have assets that do trigger probate, so the 75,000 or 100,000 threshold, here are some of the common steps that one would need to follow. So someone would, of course, need to be appointed the executor of the estate. Someone would need to have authority to collect on those assets. An application for either an informal probate or formal probate would need to be filed with a court. Notification would need to be given to all beneficiaries of the estate. And then, you must also notify all creditors that an individual has passed. And then there is a mandatory set 4-month waiting period before those assets could be distributed to the beneficiaries under the will. So if there's any creditors that are making a claim to the estate, then the executor, the appointed person of the decedent's estate, would need to wait to see if there are any secured versus unsecured claims. And then that can be a whole process. And then once that is done, the executor would do an inventory of the remaining assets, distribute to the beneficiaries under the will, or if there's no will, according to the laws of intestacy, and then close out the estate. So this is a very simple, basic list here. There's a lot more complexity to it. But again, the whole purpose here is that we want to avoid probate, and there are very simple ways to do that. So an ending point here, some tips and tricks on how to avoid probate. Very first on top of the list is to create an estate plan. And if you have created an estate plan, you want to make sure to update it again every 3 to 5 years, or if you move. So again, always keep in mind the Arizona probate laws are different than the California probate laws. So to make trust administration easier or estate administration easier, we always want to update our documents to reflect where we reside. Another super easy way to avoid probate is to establish joint ownership of real and personal property assets, or use beneficiary designations, also commonly referred to as payable on death accounts. So any account that you have, doesn't matter, bank account, life insurance, you can designate a primary beneficiary and a contingent secondary beneficiary. That is the #1 easiest way to avoid probate. Create a living will and fund the trust. So this is a 2-step process. And again, this is another thing I tend to run a lot into in meeting with clients, is that they create a trust, but they never actually fund the trust. And that is the main thing. And by funding the trust, I essentially mean creating a link between the asset and the trust. And you do that by just updating your beneficiary designations to the trust. You can also gift away assets while you're living, makes things easier that way as well. And then just making a detailed account of your assets. So I tend to see a lot married couples come in where just one spouse controls paying the bills and only one spouse knows what assets are there. So when that spouse who does all the control and management, paying all the bills, passes, the surviving spouse is left with a whole bunch of paperwork, doesn't know where to look first. So that creates a lot of, problems that can be avoided. So those are the main tips and tricks for an estate plan. Super easy solutions to avoid probate. But again, so number one thing here is that at the very beginning, you do have an estate and you do need one. So that's all I have for you today. Again, that's very basic estate planning and probate processes. But again, I just wanted to give a clear and straight suited kind of guide to what an estate plan consists of and the benefits of having one. So I will now pass it along into the exciting world of employment law, which Shar Bahmani and Meenoo Chahbazi are going to share since they practice in the same area but on opposite sides. So take it away, guys.
Hey guys, and thank you, Afsanieh, for that presentation. That was great. It's actually good to know that it's never too early or too late to get an estate plan going. So thank you for making that clear for everyone. Hello to everyone out there in the cyberverse watching us. My name is Shar Bahmani. I am a partner at the law office of Sachs Tierney, which we are based in Scottsdale, not too far away from the Arizona Persian Cultural Center. We are a full service law firm, which means that basically we handle anything under the sun when it comes to business related items. And we also, like Afsanieh, we have a estate planning group. So we do a little bit of estate planning, and we've got a couple other practice groups related to businesses such as bankruptcy and helping individuals out. Additionally, I am currently the president of the Iranian American Bar Association, Phoenix chapter. And we are, me and my colleagues, three of whom you've heard from, and Meenoo, who has yet to go because we are saving the best for last. But the five of us comprise the current board of the Iranian American Bar Association, Phoenix chapter. We are absolutely excited to be here with you guys tonight. A big thank you, by the way, before I get started, to the Arizona Persian Cultural Center. On a personal note, I just want to say thanks for everything that the center has done in such short a time. It's only been around for the better part of this decade, as far as I know, but it's astounding how much you all have accomplished. And I don't think there's enough thanks that could go around from our community to all the people behind the scenes who volunteer and who tirelessly work on behalf of the Persian American community here. So thank you for everything that you guys do, and thank you for hosting us tonight. Getting into my topic, as Afsanieh said, we're gonna be talking about employment. I represent small businesses. I represent businesses of all sizes, whether they're small, medium, or large, whether they have 1 employee or 500 employees. So I'm going to be talking about employment law from an employer's perspective. And then Meenoo, who's going to go after me, she primarily represents employees. So she's going to touch upon some of the things that people want to know from an employee perspective. So from an employer perspective, the hot topics that are going around right now, surprise, surprise, are all pretty much COVID related. So, and I know that we all have exhaustion about hearing about COVID, about dealing with it in our daily lives, and about having to, have dealt with it in this past year. Nonetheless, because the pandemic still is ongoing, there are some topics that employers want to keep in mind and want to make sure that they address and that they comply with. So the first topic that we're going to get into is the Families First Coronavirus Response Act, which I'm going to refer to as the FFCRA. And what the FFCRA did was it established federal sick time for all employees who work for a company of 500 employees or less. So unfortunately, if you're working for the Amazons or the GoDaddies of the world who have more than 500 employees, the FFCRA is not going to apply to you. However, if you have a business of less than 500 employees, you want to make sure that you're complying with the FFCRA, or did at least for the last year. And I'll get into why you might not need to comply at the moment in a second. So what the FFCRA did, again, is that for certain reasons related to sick time, it established 80 hours of sick time that's available for employees who either they themselves get COVID, they have a family member who gets COVID, or even if you think you've been exposed and need to get tested for COVID, that's also another reason why you might qualify for up to 80 hours of sick time. Now, with the law, Congress was pretty smart just because it knew that a lot of businesses was hurting. So what it tried to do was that provide an incentive for companies to keep their employees around and actually provide the sick time. So what it did is that it provided a dollar for dollar tax credit to any company who has an employee taking the sick time. And all you need to do is then make sure that anytime an employee requests sick time pursuant to the FFCRA, you document it via an email or via some other document with your human resources. And at the end of the year, turn it over to your tax accountant. And when your tax accountant's doing the business's taxes, they can apply for this dollar for dollar credit. Now, what happened at the turn of this year is that Congress didn't extend the FFCRA into 2021. What it did do, however, is that it basically made it optional, where employers until March 31st, 2021, if they'd like to, they can still comply with the FFCRA and grant the 80 hours of sick time. Now, you're an employee standing there, or if you're an owner of a business, by the same token, you're kind of banging your head saying, you know, why would I want to grant benefits that I don't have to? And the answer remains the same, that because Arizona has a paid sick time law, which we'll get into, that you might have to grant sick time under that's not reimbursable. If you grant employees sick time until March 31st of this year under the FFCRA and it's justified under an FFCRA purpose, then you can still receive that dollar for dollar tax credit. So one thing for employers to think about, if some of your employees are coming to you and they need sick time for a permissible purpose under the FFCRA, you definitely want to consider granting that sick time just so you could get that dollar for dollar tax credit. Although it's not new, one of the other things I want to quickly get into is the Arizona paid sick time statute. So hopefully everybody is aware of the Arizona paid sick time obligation by now. If you're not, probably good to get on it as soon as possible, just because this law was passed 3 years ago. But regardless of whether you exercise the option of granting FFCRA sick time, keep in mind that if an employee is sick for whatever reason, COVID, non-COVID, anything having to do with themselves, or someone who qualifies as a family member that's health related, you're still going to have to give Arizona paid sick time. So that's why employers should take a hard look at the FFCRA and determine whether it makes sense for them to continue complying with that. And just a quick primer on Arizona paid sick time and the way it works is that if you own a business with 15 or more employees, you have to give up to a minimum of 40 hours of paid sick time a year. If you own a business of less than 15 employees, it's only up to 24 hours of paid sick time a year. Keep in mind that regardless of how many employees you have, even if you have one, you're going to need to comply with it. So it's definitely a law that you want to pay attention to. As far as how the hours accrue, there's a bunch of rules set forth regarding that, but at a minimum, you need to let employees accrue 1 hour of sick time for every 30 hours they work. So if you don't have a sick time policy, again, because this law has been around for 2 or 3 years, I would urge you to absolutely take a look at it and make sure you implement a policy as soon as possible. The other thing going on with COVID right now is that there's a second round of PPP loans. If you think you qualify for a PPP loan, you want to apply as soon as possible, just because it seems like they're running into some shortage of fund issues like they did with the first round. You have until March 31st to apply, but again, if you haven't applied yet, you need the money and you think you can qualify, do so immediately, because you're going to be stuck in line waiting for a while. One of the huge benefits of PPP loans is that it's possibly entirely forgivable. So be sure you brush up on the law and what the requirements are for forgiveness. But in a way, it's essentially free money for employers to take from Uncle Sam at the moment, just to make sure they keep their workforces intact. So there's a huge benefit your workforce who remains employed, and there's a huge benefit to you too, where on the government's dime for 8 weeks, you can essentially keep most of your workforce employed. So be sure to check up on PPP loans and take action there if you haven't already. And then the final COVID-19 topic I want to get into, although it's not new necessarily this year because it's so fresh from last year, is that keep in mind as employers that you have an obligation to provide a safe working environment. This rule exists both under Arizona state OSHA rules and federal OSHA rules. And it's also a matter of common sense that, of course, we want to provide a safe working environment for our employees. And there's been a lot of confusion as to what exactly that means in the pandemic and the COVID-19 era. So it doesn't mean that you're going to be on the hook or liable just because an employee may contract COVID-19 at work. What it does mean is it's a reasonable person test where they're going to, if push comes to shove, an employee wants to get litigious with you, what a court or what a decision maker is going to look at is they're going to see if you took reasonably prudent steps to make sure that your working environment is safe. So, for example, one of the things you want to continue doing to the extent possible if you have employees coming to work is mandate that they wear masks. Mandate to the extent possible, again, if you have employees sitting in cubicles, if there's a way to move them 6 feet apart, do your best to emphasize social distancing, as weird as that might sound because people are indoors the whole time. The more you can point to different steps you've taken to make the workplace as safe as possible, the better it's going to be for you later if, unfortunately something does happen and you find yourself in a position where you need to defend yourself as saying that we did provide a safe working environment. And finally, along those lines, I can't emphasize this enough, document. So if you are taking all these steps to make sure that you're providing a safe working environment, make sure you're documenting it, make sure you're keeping up to speed with employees and emailing them every couple of weeks or at least once a month and just reminding them, what your workplace rules are, that if any of them has any questions or concerns, or they can come talk to you. And really, and also the fact, reiterate that you're following CDC guidelines to the best extent possible, and that they should do the same, that they should keep up with the information that the CDC puts out just because it's a moving target, and everyone needs to keep up to speed as this pandemic continues to evolve around us. And then finally, a non-COVID issue, which Saman John brought up earlier in his presentation, but the good people of Arizona have seen it fit to join some of the other states in passing recreational marijuana as legal. As far as how that impacts you as an employer, it doesn't for the most part. So that's good. The law, in fact, expressly says that it does not restrict the rights of employers to maintain a drug and alcohol-free workplace or affect the ability of employers to have workplace policies restricting the use of marijuana by employees or prospective employees. So your policies can remain intact if you want to allow marijuana because it is now legal and not take adverse employment action against an employee who tests positive for marijuana, you can do that. If you still want to take adverse action against an employee who tests positive for marijuana, you can also do that. Just two things to keep in mind. One, the medical marijuana laws are still in effect. So the passage of this recreational marijuana law actually didn't change anything with respect to medical marijuana. So that means that if you're drug testing an employee, they test positive for marijuana, you have a policy that says we get to fire you on the spot. You don't want to do that. The first thing you want to do is talk to that employee, disclose the drug test results, and ask them if they have a medical marijuana card. Because if they do, then there's going to be some added follow-up just because, again, the med marijuana laws are still in effect. So make sure you tread carefully there. The other thing to keep in mind too that's a little bit interesting from a legal nerd perspective is that if your policy was written in a way where you can take certain action against illegal drugs, you might need to get an attorney or look at it yourself to revise the policy a little, because keep in mind that an argument can now be made that marijuana is a legal drug. So if your policy only excludes against illegal drugs and you want to continue doing that, you're going to need to revise it to change the definition of what is illegal and what isn't a legal drug in the wake of Prop 207 passing. That is it for me. I will now pass it to my esteemed colleague who seems to be sitting late in the courtroom waiting for us. So Meenoo John, please take it over.
Thank you, Mr. President. Salam va khosh omadin. Thank you so much to the Arizona Persian Cultural Center for co-hosting this event with us. And thank you so much to our audience for hanging in there and staying on the line for almost an hour now. I know you've been on the line for a while, so I'm going to keep my presentation short and sweet. First, we talked a little bit about some of President Biden's reversals of Trump's executive orders. President Biden also reversed some of Trump's executive orders for federal employees. Trump had wanted to make it easier to fire and discipline federal employees, and he had instituted executive orders on that, and they've been reversed. So federal employees have more safety and security now. And then I'm also going to be talking today about a lot of changes that are expected but not yet instituted. So these are prospective changes that might happen, but don't get worried because some of these or don't get excited or worried depending on your perspective, because a lot of these have not been instituted yet. I'm just going to be talking about what is expected from the Biden administration and what Biden has said along the campaign trail as well as after being elected. So first, with respect to the federal minimum wage and federal employee minimum wage, Biden has said that he is going to increase the minimum wage. He's going to try to increase the minimum wage in the private sector to $15 an hour. And right now he does have the ability to do so with the Senate and the legislature in the House. So that is projected to be something that will happen. Already with respect to federal employees, he has instituted an executive order that says agencies must identify federal workers who are earning less than $15 an hour and make recommendations to help raise their wages. So already with federal employees, he's taking action in that regard. And we're expecting that the same will happen with respect to private sector employees as well. And if this were to happen, what's likely is that it's going to be on an incremental basis for the next several years. For example, Congress has one model projecting reaching $15 an hour by 2025. So whether this is an issue that's very exciting and that you're very much looking forward to, or one as a business owner that you're trying to reconcile and deal with and might cause challenges for you, irrespective of your perspective on this, it's not going to happen overnight. It's going to take some time. They had wanted to include, some Democrats had wanted to include this with COVID relief, but that doesn't seem like it's going to happen either. So it's going to take some time to get the bill passed. And then on top of that, there's going to be incremental changes. And then next, in terms of overtime, there's an expectation for there to be an increase to the minimum salary exemption for overtime exemption. So that is going to be more employee friendly as well. That's something to watch out for. With respect to classification of workers as employees or independent contractors, this is a very interesting issue and it impacts a lot of Arizonans who are classified as independent contractors. So basically, Biden has said that he is advocating for the ABC test. The ABC test is a law that has been instituted in California, which basically makes it very difficult for employers, and I mean very difficult for employers to classify workers as independent contractors. The ABC test is a really simple test, and it basically says that if the employee is performing work that is within the usual course of the entity's business, they're most likely not going to be an independent contractor unless there's some other exemption. So for example, if you're working with a computer engineering company and you are working as a computer engineer, you are not most likely under the ABC test going to be able to be an independent contractor because you're performing the same work. But if you are a plumber that services the office for the computer engineering company, then yes, you would be an independent contractor. So that's one of the big factors is, are you doing the same kind of work as the company or are you doing completely different work? Another factor with the ABC test is whether there's extensive control or direction over the worker. So if there's extensive control, then you're basically an employee. If there isn't extensive control, then it's possible that you could be an independent contractor. And then the last issue with respect to the ABC test that we look at is whether you have multiple customers or clients and not just one employer. So again, if you're a computer engineer working for the computer software company and you only work for that computer company, then most likely under the ABC test, you wouldn't meet that requirement. You would be an employee, not an independent contractor. But if, again, you're a janitor and you have like multiple customers who need your help and you go from office to office helping customers, then yes, more likely you are going to be an independent contractor. So that test will make it, in some ways, what Biden has said, much clearer and simpler. And then in other ways, it will create a lot of restrictions for employers. And then conversely, it will create a lot of rights for workers if that is passed, because employees get many more rights than, as opposed to independent contractors. However, there is an Arizona Declaration of Independent Business Status, which is completely different, than what we have in the federal sector and federal in terms of federal law. And this Declaration of Independent Business Status basically allows employers to ask their workers to just sign a declaration saying, yes, I am an independent contractor and not a W-2 employee. And just with this declaration that is signed under Arizona law, if you follow the legal requirements of this declaration, there's a rebuttable presumption that you are an independent contractor and that you are not an employee. So if Biden does pass, this federal law, it'll create a very interesting juxtaposition between the federal law and the Arizona law. But again, this is something that we will have to wait and see about. This is not something set in stone yet. And then additionally, I wanted to touch upon some additional laws that are expected in the area of discrimination and equal pay. We have a law right now, the Equal Pay Act, that states that males and females should receive equal pay for work requiring equal skill, effort, and responsibility. However, there are major loopholes to that law. One is the factor other than sex exemption. So Biden is expected to close that loophole to provide more protection for employees based on sex, based on gender. So you don't have situations where males are making significantly more money than females, or even vice versa, for doing work that's substantially similar. So that's also expected. Additionally, there was a Supreme Court decision in June 2020, Bostic versus Clayton County, Georgia, which provided rights to individuals in terms of equality and with respect to sexual orientation and gender identity in the workplace. So it provided extensions of protections in that area. And Biden has expressed support for expanding those protections as well, and also including in protections for those who are pregnant, senior, and disabled employees. So that's all expected as well. Then additionally, Biden is expected to institute laws to provide up to 12 weeks of paid Family and Medical Leave Act. So right now we have the FMLA, which provides for up to 12 weeks of leave, but it's unpaid leave. The federal requirement is only for unpaid leave. So there is some indication that Biden will try to institute a law, try to pass a law that will provide for 12 weeks of paid family and medical leave, which will be a huge benefit to employees. Then in terms of discrimination, some additional expected changes are in the area of age discrimination. It's right now, you have to show that if you have an age discrimination claim, you have to show that it's the but-for cause of the harm, which is different than other forms of discrimination. You only have to show it's a motivating factor. So Biden is expected to change that to make it easier for older employees to bring age discrimination claims as well. And then lastly, what I wanted to touch upon is that Biden has proposed placing limits on non-competes and non-solicitation agreements. He has stated that he will work with Congress to prohibit non-competes, with the exception that those that are absolutely necessary to protect a narrowly defined category of trade secrets. So non-compete agreements, as my colleague Shar Bahmani will tell you, are rampant in Arizona, and you definitely have to be careful not to violate them. So it'll be very interesting also to see what happens with the Biden administration and whether he institutes some federal limitations to non-competes, because that will absolutely impact Arizona employees as well. And ladies and gentlemen, that is the conclusion of my presentation, but I would like to leave some time open if we have time for questions. And I saw that there are some questions. So I will pass the baton to my colleague Afsanieh, because it looks like there are a few questions regarding trust and estates.
So before we get into the Q&A portion, first of all, I just wanted, on behalf of the Persian Cultural Center, I wanted to say thank you to the Iranian American Bar Association Phoenix chapter, to all of you board members who have taken the time to come talk about your areas of expertise and tell us about the new laws. We very much appreciate that. If there are any questions, now is the time. Feel free, you can type the questions in English or in Farsi in the chat box. There is also a way, if you prefer to ask your question live, you are able to do that in the Q&A, using the Q&A mechanism, whichever one you're comfortable with. And so, yeah, as Meenoo John said, we do already have some questions. So passing it over to Afsanieh. Afsanieh, take it away with some of the questions that you see.
Hey, Saman John, my computer is frozen, which is funny.
Okay. That's
so
okay.
I can't view the chat box.
That's fine. So I'll read the question for you. The first question we have came in our chat box for you. It asks, if you create a trust with an attorney, can you have another attorney update that trust, or do you have to go back to your first attorney?
No, there is no requirement that you have to see the original drafting attorney. Because of course you're going to move, out of state. That attorney may no longer be in existence when you want to update it. So you can go to any estates and trust attorney and have them review your documents.
Okay.
So no requirement.
Now, another question. If your beneficiaries differ between your legal documents, which document supersedes? I guess you can narrow that question, since it depends on the document we're talking about.
Okay, so I guess I'm not quite following that question. So one document's going to control. So if you have a trust, the trust and will are going to work hand in hand, but the trust would be the controlling document. Whereas if you just had a will, and let's say you executed several wills over a time period, the latest will would supersede all the prior ones. So there's no reason why you should have conflicting documents with different beneficiaries. However,
sorry, I'm going to jump in and say I asked the question. So let's say you have life insurance with company A, and then they ask you who the beneficiary is. You list person A, and then your trust lists person B. So what happens if they conflict?
Right. Okay. So I understand where you're going now. So you can definitely designate beneficiaries outside of the will. Sometimes we have a will that, for example, just has everything in the trust estate going to my children. Whereas maybe you want to provide for other family members outside of that trust document. You can certainly designate that through the beneficiaries. So whoever is the controlling beneficiary on an account, whether it be a trust or an individual, is what is going to control. So you can certainly, so there's different crafty ways you can provide for beneficiaries, whether it be within the trust document or specifically with a designated account, you can designate an individual beneficiary.
So the designated account supersedes your trust?
No.
It doesn't. Okay, well, I'm missing.
Does not.
Okay.
However, if you don't designate a beneficiary and have a trust, then at the end of the day, once that asset is collected, it'll go via the terms of the trust.
That's why you guys get paid the big bucks, because I still don't understand it.
Well, come and see me and we will break it
There you go.
down. That's what we're here. That's what we're all here for.
So another probate question before we turn to other questions. This question from Firebo John: is it too late to start a trust when somebody has dementia? And part B of that question is, can a family member do the trust?
So that is a case-by-case basis. So if a person, first of all, must be of sound mind to execute any legal document, estate planning or otherwise. So if they do have onset early dementia, that's an assessment that really needs to be made in person to see whether they can. And that happens a lot of times where I might even have to go to pre-COVID, when I went to the hospital, where I had to make that determination whether the party understood the document that they're executing. So really at that point, it's a case-by-case basis. But part two of that question, you cannot create that document on behalf of the person who does have the condition. So that's why it's important to get everything in place when you're still, you know, of sound mind and healthy and able to make those determinations.
Okay, thank you, Afsanieh John. I have a question in the chat in the Q&A section from Farid Akhbari. Do you have any updated information on OFAC? That's the Office of Foreign Asset Control. I assume that's sanctions and immigration related. Arash, that might touch most closely with what you do. Do you have any updates on what
Yes,
the OFAC related items?
No, that's a very complex area, and we don't touch that area.
Okay, so that's a whole. I know Department of Treasury. You know, Treasury Department is the one that does those, and that's a pretty, like you said, a pretty complicated matter. So I guess anybody else know? Does anybody else track that, or anybody would you know somebody that would be familiar with Department of Treasury and Office of Foreign Asset Control? We could find somebody maybe to answer that question.
The only thing I can chime in, I don't know anything about the subject area, and this is, you know, it's gonna sound like just passing you off, but the primary attorneys who I've come across with that deal with this tend to be in DC, just because it's kind of related to, and there are a lot of options for you. So if you want to email one of us, maybe we can put our heads together and introduce you to someone. I see Meenoo nodding her head. She might know.
Yes. So Eric Ferrari, who is the previous president of IABA, he focuses his practice a lot on OFAC, and he actually came out with Farhad Alavi, who also focuses a lot on OFAC. They actually both came out and did a very extensive presentation on OFAC. So I would recommend that you contact one of them. I'll see if I can.
I have their contact information. So whoever is asking that question, I can.
Yeah, we might be able to post it in the chat. But if there are any other questions.
Let's see. So yeah, well, hopefully we can get an answer to that. Or we do have a few more questions coming in the chat. This question says, what happens to joint accounts with 2 children upon death? Is the distribution equal? Afsanieh, is that?
So can you repeat the question? So the joint accounts.
Yes, it doesn't say what kind of accounts. I don't know if that means a bank account or a car, you know, ownership of a vehicle. I don't know if it means property, but let's assume bank accounts for a moment, I guess, because it says accounts. Feel free, and I'm not sure who asked the question is coming in from a phone number that I don't recognize. So if you want to narrow the question or be more specific, please, you're welcome to do so. But it does say accounts. So what happens to joint accounts with 2 children upon death? Are those equally distributed?
So I'm presuming, so if there's a joint account, the joint account holders pass and there's 2 children, or?
let's go with that until we hear otherwise.
Okay, well, if those two children are designated as beneficiaries on the account, you can divvy it up however you please. You can do 25% to one child and 75% to another child. If they are not, if there's no designation on the account, depending on the value of the account, it would trigger a probate. So again, if it hits that $75,000 threshold, then it would be determined that way. So I guess some more specificity to the question would help me guide you through that, but there's many different ways that could carry out.
Okay. This is a question for whoever wants to tackle it. Can you still be charged for possession of marijuana under federal law? I mean, I can just initially say that marijuana is still an illegal substance. I believe it's a Schedule I substance under federal law, so that means it has no recognized medicinal use or otherwise. So from what I can tell you, it's possible. From what I have read, at least the policies of past administrations, they are a bit more selective with enforcement in states that have legalized medical or maybe recreational, but it's very dependent. I mean, it depends obviously if you're talking about 1.5 grams versus a bunch of kilos. Of course, if you have kilos of marijuana in your trunk, the Arizona law will not cover you. As one county sheriff recently posted online, he said, yeah, marijuana might be legal, but you can't have 400 kilos of marijuana in your trunk. So it really depends, but the bottom line is it's still illegal under federal law, and so it's still a risk. So one thing, for example, I would say it's legalized here in Arizona, it's legalized in California, but if you cross state lines with marijuana, that could be a federal offense, right? So don't assume, let's say you're traveling, maybe you have gummies in your bag or something, don't assume that you can just take it with you anywhere you go. That might be, that might cause you some problems. Again, is it likely? Hard to say, but know that there is still a risk because it is still illegal under federal law. Anybody want to supplement? Okay. We are getting some more questions coming in. So thank you all. From Fariba, a question for Meenoo. What do you think of Prop 22 in California, which did not pass?
Yes, so there was a Proposition 22, and it was basically a situation where a lot of the workers who work for example, Uber and Lyft, there was a question about whether they should be classified as independent contractors or should be employees and should have all the rights of employees. And there was a huge lobbying effort by Uber and Lyft to basically say, like, no way, we cannot survive having employees. We have to have independent contractors. And Uber and Lyft won the day. And so basically, there are some limitations even on the ABC law in California. There are different exemptions under the California law that have been instituted based on lobbying and so forth. So certain subgroups that you would expect to be subject to it aren't, and it is more technical. And what we're going to be waiting for with the Biden administration is we're going to see whether they have this, similar or broader or narrower carve-outs and exemptions for who would be an independent contractor and who would not be classified as an independent contractor. So all of that is really yet to be seen, in terms of the federal law. We don't know yet what Biden's going to do exactly or what the law is going to look like if it comes out of the House and Senate. California, for the most part, the ABC test is there, but as you noted, the Ubers and Lyfts of the world won the day, so they're still able to be independent contractors.
We have a question in Farsi. Ms. Shirin is asking, after the passing of my husband, I have only collected my own Social Security benefits. Am I entitled to some of his benefits now? Don't know if anyone has any information on this area.
So again, I hate saying this, it depends. When he started, so when he started receiving benefits, I don't know specifically though, unless I had more information. Because sometimes you could be entitled to all or some, depending on certain circumstances of those Social Security benefits.
Okay, thank you, Arash. Thank you, Meenoo. Shar, thank you, Afsanieh. We have one more question. This one looks like it's for you, Afsanieh Jan. Do children who are not residents or citizens, so there's two questions, it sounds like, have to claim, no, do children who are not residents or citizens have claims to inheritance?
Yes.
Okay.
Short answer, yes.
All right, there we go. Look at that. We got an answer that was not, it depends, from a lawyer. Amazing, amazing.
I could
That's
go
good.
on and on, but I'm going to just make it short and simple and say yes.
That's great. That's great. That's great. Okay. Well, I don't see any other questions. Is there anything else anybody else wants, any of you, the panelists, wants to touch on before we conclude our program?
I will just say, so one thing here to look out for. So I believe I forgot to introduce, my involvement on the board, but I am the Arizona National Board Representative. So there are local chapters across the US and I represent Arizona. And we do have a national conference, and this year it'll be virtual due to the pandemic. But last year we were supposed to celebrate our 20th anniversary of IABA being founded. However, now it's going to be our 21st anniversary. We had to push it back. Unfortunately, we were going to have it in New York, but now it's going to be virtual, which is exciting. So you can all attend and see chapters across the country, what they're doing. And we have a fabulous list of panel speakers, so professional development speakers, legislative and judicial speakers. It is going to be on Saturday, March 27th. And I believe it is from 10 a.m. to 1 p.m. Don't quote me on the time, but I am sure on the date. And we will be sending out the save the date shortly with these speakers. So I will make sure to let the center know of all the specifics and post it on our website. If you do not follow Phoenix IABA, Iranian Bar Association on Facebook, please do follow so you can get all updates regarding the conference and future events. So be on the lookout for that.
Nice, Afsanieh Jan. Thank you very, very much again to all of you IABA board members of the Phoenix chapter for what you do and for taking the time to enlighten us and talk to us about new laws and proposals. We've been invited back already, so I think that's a good sign. Maybe in 4 to 6 months we can schedule a follow-up webinar and see what the status of some of the proposals that we have talked about, both from the state laws and in the federal laws and regulations, and provide an update and where things are at. And I'm sure we would love to do that. And thank you to the Arizona Persian Cultural Center for having us. Thank you all for attending and for your questions. And we will see you soon. We will also make our contact information available. I can send that around. We can maybe send around an email and send it out to our list. So if anybody has any particular questions, or if you also would prefer to make your contact information available now, you can do that in the chat So folks can reach out to you if they have any questions about your area of law. So some of us will either put our contact info in the chat, and if not, we will make sure you folks know how to reach any of us if you have any specific questions for us.
Oops. I guess I posted mine twice.
That's okay, thank you. So Meenoo has posted her contact information in the chat if anybody has any employment law related questions.
I just want to follow up and say that unfortunately in Arizona, employees have very limited rights. The state laws are weaker than our federal laws with respect to discrimination and some other areas as well. So, you know, unfortunately, we're not in the best position as employees in Arizona, but I'd be happy to, you know, speak briefly with anyone if they have a question, especially if they're participating live today.
And I'm just going to just say my email because unfortunately my screen is still frozen. I'm working with two screens here and I'm not really sure what happened. So if anyone has any estate or trust related questions, my email, and maybe if one of you guys can type it for me because I don't know what's happening. My email is arassti@lwazlaw.com. Thank you, Saman.
I'm going to ask a question because I have employees, I should say, I guess, the people who work for me who are actually, they're from India, and they all need immigration lawyers for their immigration needs, I should say. And which one of you, I guess I you know,
Arash.
yeah, which one of you guys can help with the helping them with their immigration needs and citizen, or I should say, because they're here on visas and they want to convert, and they're full-time employees. So I guess I'm looking for suggestions.
I practice immigration. Our firm specializes in immigration. We do a lot of employment-based immigration as well, H-1Bs, converting it into employment-based visas, EB-2s and EB-3s. I'll be happy to look over their cases.
Most definitely will be contacting you. Thank you.
Okay, well, and with that, Arshia John, we'll let you be the last question. Thanks again, everybody. Thank you to all of our panelists. Thank you to the Cultural Center for hosting us. Thank you for all who attended. And we look forward to seeing you again later this year with updates on all the fun and exciting things we talked about.
Thank you, everyone.
Thank you.
Thank you.
Yes, thank you, everyone in Arshia. Thank you very much.